This meeting of the Board of Zoning Appeals to order. This is the regular monthly meeting for February. The first item, well, roll call. I guess I'll take it. Bill Anderson. Here. Jennifer Matthews.
Here.
Alex Sharp, I'm here. David Connick. Chris Berg. Here. So everybody's here. The first item on the agenda is adopting the agenda with any changes or additions or deletions.
I'd like to make a change to the agenda. I'd like to move our new business first, and then adoption of our minutes and everything else just to slip on down.
Is there anything else?
I'll second it.
Okay. Is there any discussion on that? All in favor?
Aye.
So otherwise, are we approving it? That's what
That's-
okay. Okay, so,
I move be approved with
okay.
the reordering.
okay. So we're going to take now the Dodd Z1712-07 Dodd appeal. Okay. And let's see, who's here? You're here to represent the Dodds?
That's correct.
You're Robert Light?
That's correct, Mr. Chairman.
And
I'm James Watson. I'm actually staying at the Doc's house and would like to speak as well.
but you're not representing them? Okay. Okay, now you're representing the county? Is anybody else representing the county? No attorney or anything? No. Okay.
We are.
I guess that's, okay. So we can start, one thing that I wanted to start out with, and I was trying to look at this case and understand it a little bit, and I think partly because of some issues that came up with Mr. Connick, and I was thinking about it, is I think personally, I think there's two aspects to this. One is that whether the letter, the determination seems to have overridden the previous determination that Debbie Kaiser had written, and I'm glad she's here because maybe she can answer a question or two if it comes up. So I was interested in knowing how that came to pass and why this new letter was actually generated in the first place. So that's something that I was interested in, because I'm not sure at what point does a ruling or determination generated by a zoning administrator, does it just get overridden by a new one? Or, because there was one generated a couple of years ago. And I don't know if you were aware of that when she wasn't aware of that. Okay, so anyway, so that was one question that I had. And so depending on the answer to that question, it may render a lot of the discussion not necessary, but I'm not saying we won't discuss it, but that's my feelings. I was hoping to divide it into two sections. One was to sort of talk about how this originated in the first place and why, and whether it's really applicable. And then assuming we make that determination, then get into the meat of what the determination is and the merits of
The appeal.
the appeal. Well, the appeal of the determination. So, is there any thoughts on that?
That seems a very reasonable avenue of approach.
And then
I'm
go ahead.
just waiting for you.
Oh.
I'd like to go back to the letter of,
Well, wait a minute, we're going to talk about whether we're going to do this in two parts
Yeah,
before we
two
get to
parts.
it. Well, wait a minute, obviously, I don't agree that that's something that we can do. I think, we had a big fuss about this the last time we had an appeal, and Ms. Matthews was insistent that we follow 15.22312 of the Code of Virginia, which says exactly what the order of doing an appeal is, and no more and no less. And I personally, I didn't agree with that, but for other reasons. But I didn't agree with it because I think that the way that is written, it keeps the it keeps any adjoining neighbors or other interested parties from speaking. That's the part I had a problem with, but I guess I got outvoted. And then we all agreed to be bound by an Attorney General's opinion that I checked today and unfortunately hasn't been issued yet. So we don't have any guidance on that from there, and so all we've got is the code section, and the code section says that we're supposed to hear from the zoning administrator, and we're supposed to hear from the appellant, what is their view, and that's it. And that's what you all voted to do the last time, and I think, but I think A, that's the law, and B, that's consistent. If I may, is there anybody in the audience that wants, besides this young gentleman that said he's living there, is there anyone else that claims they have some interest and wants to be heard on this? You do? And do you want to present evidence, or you just want to say what your opinion is?
Well,
I'm not asking for it now, I'm just
Is
asking
this
you.
about this particular
Yes,
Dodd case?
yes.
Okay.
Okay,
Now, you had, I think we had discussed this, and if the Attorney's General opinion had not come back, we were probably going to allow some public input.
okay, I'm not,
Was what,
I don't have a
was what we said,
problem.
and I was not really talking about public input necessarily, whether or not to do that. It was simply about, I was trying to define the question.
All right, well,
Is
but-
what I'm interested in.
All right, so that's one part I wanted to say about it. In my view, if this lady and that gentleman, or if for that matter, anybody else wants to say anything about it, my view is that the state code is very clear. On an appeal, you have to have a public hearing, and I'm just really saying this for the benefit, not so much of the board, but some of the people who may be unfamiliar with what has happened in the past. But if it's a public hearing, you've got to let the public speak. Public hearing doesn't mean they get to come and listen. Public hearing means we're supposed to hear
that's
the
where
public,
No, I don't know.
not the
I'm
public.
not-
All right, that's my view of it.
Okay, but I don't necessarily.
All right, I understand that the rest of you may or may not agree with that, but that's my view of it. But we don't really have a big issue about that tonight. The second part of this is which I don't agree with your proposed bifurcating of this issue, is the zoning ordinance says what it says. It's got definitions in it, and they say what they say. And it doesn't make any difference if a zoning administrator makes some kind of a judgment call based on his or her interpretation of the ordinance. If it's incorrect, it's not binding. The ordinance speaks for itself, in my view. And so, if Fanning Baumgartner used to do it one way and Colonel McNear did it the opposite way, and then I came along and said, in my usual way, they're both nuts, so here's my third way of doing it. And then after me, there were 3 or 4 other zoning administrators who said, Connick must have been on drugs, so we're not going to do it that way. It doesn't matter. The ordinance says what it says. And the board's not bound and can't be bound by an incorrect interpretation. And if nobody appealed any of those decisions, then, or supposed determinations, if somebody had appealed it and went to court, and the court said what it was, then I think, yeah, it would be binding on us, but I don't.
We did have a decision, an opinion that was rendered by Debbie Kaiser, who was working with John McCarthy, and that's not that long ago, that's a couple of years ago.
Okay, so
Anyway.
I mean, with all due respect to both of them, my reaction is that none of that has any, it may have some bearing on it. I mean, if you agree with what their interpretation was, but I don't think it prevents us, is all I'm saying, from, and what we've got to do tonight at this hearing, after hearing from the parties in interest, is decide if the zoning administrator's decision was correct or not. Period. And if you want to take into account what some other zoning administrator said at some other time, that's your all's prerogative. But I don't consider that that's a separate issue. I think we have to hear the evidence, like the statute says. I guess we're going to hear from Mr. Light, and then we can take whatever note of what these other people want to say, and
Okay,
hear from the zoning administrator, and
I will yield to you.
and then go from there. I mean, if you want to bring those things up,
No, I think,
fine,
well,
but
you,
I think we
you
gotta do
heard
it
what
that
I
way.
said. So, yeah, I'll yield to you on that, but,
Okay.
okay, so there was another issue, and I know we've been back and forth about this, and I don't want to obsess about this, but the Dodds had brought up at one point, Art Goff had brought up at one point that you did have a conflict of interest in this application. Now, I know you've gotten a letter from Art.
Right?
Mr. Light, did you have any opinion or anything to say about that?
The only thing that I had, Your Honor, I discussed this.
And you can introduce yourself just to make sure.
It's at 15.
Well, he's open.
For the record, Robert Light with the firm of Lawson and Silac, address 43 Chester Street, Farm Royal, Virginia. I represent the applicants in this case, the Dodds, Desmond and Heidi. I read, Mr. Goff and I discussed his email, I read it. The question that remained with me was, I understood his analysis that if we talk about the substantive merits of the determination letter, that it may have generally applicable, it may be generally applicable to the public. Therefore, his reasoning was that the conflict for Mr. Connick was no longer there in this case. However, as you've been kind of discussing around is Virginia Code Section 15.2-2311C says, if you have a prior written determination by a zoning administrator or other zoning officer, 60 days elapses, the person who asked for the determination relies on it, changes their basis. It is no longer subject to modification, reversal, renewal by anybody.
Now, which one are you talking about there? Which opinion are you talking about?
I'm talking the general law, is that
No,
if
no,
you,
but I mean, you're referring to one, is that the conflict of interest opinion, or is that the,
well, that's what I'm getting to is one of the issues in this case is the applicability of 2311C, which is Ms. Kaiser's previous determination. Under that, it would be applicable to the Dodds, because if you find that that her zoning determination conforms to 2311C, then you're making a determination that ultimately it gives them vested rights under 2307. So therefore, in that circumstance, it's your decision on the 2311C issue is therefore not generally applicable to the public at large. It's focused on the Dodds property. And so therefore, there still remains a concern, given the prior conflict memo that Mr. Goff gave, that as to the specific question of the 2311 question, there is a conflict and there should be a recusal. Now, as far as if you, depending on what the answer is to the 2311 question, and the BZA decides to move on into the more substantive question, like I said, I understand Mr. Goff's position on that point. But I think there is a concern as to making a specific determination as to the applicability of 2311C, because that will apply specifically and only to the Dodds property, as they were the ones who requested and received the determination from Ms. Kaiser.
okay. Do you have anything to say on that issue? No. Yeah, I wasn't sure. I thought maybe Art would be here since I thought he was representing. But anyway, but that's fine. Do you have anything to say on that? No.
I don't, first of all, I didn't agree with Art Goff's first letter, and for the reason that I don't think that there's any interest in the
Which
transaction.
letter is?
The one back in August or
No,
whenever
it
it was.
was this determination.
Just whenever it was last year. I didn't agree with that. And so, but out of an abundance of caution, I asked him for an opinion letter, and I don't know when Mr. Leahy spoke, but Mr. Goff gave me a letter, and I'm relying on it.
He did share that with
Well, I haven't heard anything else from Art, and I will say, although I'm not under any obligation to disclose it, but because I thought Art might be involved in representing the county, I went to the additional trouble of sending Art's letter down to the Conflict of Interest Council in Richmond and asked them for an opinion, which I got, and they agreed with Mr. Goff that it's a matter of general public interest because it involves an interpretation of the ordinance that applies to everybody across the board, and that I don't have any personal interest in the transaction. My client doesn't have any personal interest, my client not here, and my client doesn't have any personal interest in this
Even though she's
issue.
an immediate neighbor?
Well, she's not exactly an immediate neighbor, number one, and number two, whether or not it's rented for 30 days or 29 days or 31 days, it doesn't change the fact that it's a rental thing. So anyway, that's what they said. They agreed with Mr. Goff's opinion, and so I'm relying on those two opinions. I mean, I don't know what else to do or where else to go. The first I heard about any discrepancy or any disagreement with what Mr. Goff said was about 5 minutes ago. So I'm relying on that, and I
Okay,
don't
so you're
intend
not
to recuse myself.
Okay.
No, I'm not.
I mean, I'm not gonna obsess over this, so, okay. So the first item is gonna be to hear from the
Zoning administrator.
zoning administrator. So Michelle, if you go through.
Okay.
I guess I
You have to swear, you got to
Yeah,
swear people
Michelle,
tonight, yes, sir.
You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
And you can introduce yourself just for the.
I'm Michelle Summers, I'm the current zoning administrator. On November 8th, the Dodge requested a determination from me as a zoning administrator regarding the property and if I deemed it was a tourist home or not. I met with the county attorney, reviewed the letter, and rendered my determination dated November 17th.
Before we dispense with that now, I'm just gonna bring it. Okay. So basically, are you showing the letter up there? Or she's gonna put her letter up there.
The prior zoning administrator, me, Mr. David Dameron, had sent them and Mr. Art Goff had sent them a letter that they were running a tourist home and needed to apply for the appropriate permits.
That's your letter. It is.
Center.
Okay. Can you find it?
Here we go.
Can everybody read that?
Can you make it a little bit bigger?
Well, not that big. So, I guess I'm allowed to ask questions.
Well, I don't know, she's going to testify, and then I guess we can all ask
Is that your testimony right now, or you have more to add? Okay,
Well, could you summarize
the letter.
the letter just for the audience?
Okay. A single-family dwelling unit is permitted by right under the current zoning ordinance. If the renting property for 30 continuous days is constituted tourist home use, yes. Overnight guests where no agreement or rent is exchanged, subject to minimum or maximum occupancy, no. Are there other zoning ordinances that would further limit the use or advertising of our property for rent as your single-family home? No.
Okay, but the main one at issue is number 2, I guess.
Okay, I'll go ahead and read that.
Yeah, you might as well.
If renting the property for 30 continuous days constitutes a tourist home use, what is the minimum consecutive period for which we may rent our property and the use be treated as a single-family dwelling rather than a tourist home? In other words, what is the minimum consecutive rental period which separates the rental of a single-family dwelling from a tourist home? I included the definitions of a single-family dwelling and the definition of a tourist home. I went on to say,
And
a
is
tourist
this
home,
out of the ordinance?
that is straight out of the code.
Out of our code?
Out of the
Okay.
zoning ordinance. Is distinct from a bed and breakfast in that the term of accommodation for guests is generally longer than 1 week, 7 days. The code does not set a time frame for a rental. Most rental homes or a single-family dwelling are leased for a year at a time and
And
month-to-month payment.
that's your opinion?
Yes.
Okay. So where it said the code does not set a time frame, that's where your opinion started?
Right.
Okay.
A single-family dwelling is the place for a family to settle down. Even if it's advertised as a 30-day lease, it would be considered a tourist home.
And then the other questions, I don't think you're appealing the affirmative answers.
No, that's correct. Paragraphs 1 and 2 of the
One
letter.
and two, okay. Okay, is it anything further to add?
Yes, sir.
Is it any questions?
Yes, I have a question. Why did the Dodds contact you for a ruling as to the duration of rental?
I believe that was part of an interpretation from Mrs. Kaiser that if they rented it for 30 days or longer, they would be exempt as a tourist home.
And that, but then
But they-
something happened to get
Miss-
them to,
Mr. Dameron sent them a letter that they needed to apply. And that's when they asked for a determination letter from me. That was when he was leaving and I was coming on board.
And so did they bring up this previous determination that Debbie Kaiser made at that time?
Let me check.
You get your chance.
Then I received, did receive response from Mr. White. And that is when they asked for a determination.
But when did, so there was no reference to this previous ruling
They submitted it with their application.
for this appeal?
Didn't Mr. Goff send him a letter initially?
He sent him a cease and desist letter on October 5th.
Fifth.
That's okay, so and
So
too
that was
bad.
before you were zoning administrator, when Mr. Damon was still.
Correct.
So you inherited this.
I did.
Nice.
Okay. And so he basically notified them, so this was the first communication to your clients, I guess, this cease and desist letter?
I object to that question. How does he know what was the first communication to us?
Okay,
Even if he was on trial.
okay,
could
this
he
is
answer?
this is what initiated this issue.
That's my,
Okay.
yes.
And it was a cease and desist letter, and it basically just says that they're operating illegally in violation of the county code, and then it outlines, what failure to cease and desist means, and et cetera. So, okay, so that was the commencement of this, and then they responded to this, and then that generated a request for a letter.
That is correct.
Okay, and that's where your letter.
For ruling, for determination.
Determination,
Okay.
okay,
Nice.
Sure.
You done?
yes.
go ahead.
Do y'all have anything?
Not right now.
Well,
All right, my question is, what, do you know, what advertising or other activities that the Dodds have engaged in?
I believe they were advertising on Airbnb.
And do you have any copies of that? I mean, did you, was that something that they handed off to you, or did you verify?
I verified it. There was copies in the file, and then I went online and verified that.
Well,
and you verified something today.
I did,
Okay.
right before the meeting.
Here you go.
See what you've
Is
got,
this
looks like one I
or
got.
is this from a while ago?
Do you know when you got that?
She got that at November the 11th.
So,
That's-
11/7.
The 7th.
Okay, great. What's the number on it? 7? What's the number? This number. That's it. Okay, it's the same thing. Great. Okay, we gonna put that in the record?
I haven't seen it.
This is just a printout. Is this the same thing?
Yeah.
It's a different date or the same?
It's the same,
Okay.
and it's in color too. Living color, I would say. No pun intended.
So that's a printout of their advertising on their website, on the VRB August.
So this was basically the day after you got the letter.
The day after you got the Dodds letter. Okay, well, can we have our exhibit back, or you can have mine if you want, it's just.
We'll just get a
Now,
copy.
who was this? This was Michelle's.
Right, so once, can we have that marked, I mean, can we, Mr. Chairman, can we start putting some of this stuff in the record?
Sure.
All right, let's put
Well, this is already in there.
Well, I don't know that it is in the record. We were just supposed to be marking these as exhibits, so let's put Mr. Goff's, letter in as exhibit 1, okay?
Now, who is keeping this? Are you keeping it?
I don't know, looks like the Vice Chairman's doing it. Great.
Okay.
And let's do their request from Lawson and Silex, Mr. Light's letter of November 3rd. Let's make that exhibit 2.
And this was where, okay. Actually, right exhibit 2, I want to look at that.
And what's this? Oh, this is from the, oh no, this is an email, that's November 8th, let's make that exhibit 3. And then let's make that advertisement exhibit 4. And then I think we're all caught up.
Okay, good. Well, I don't want to hold it usually.
Now, which letter are we making for exhibit?
Well, there's one from you in response to Art's cease and
It's
desist.
like it looks like one's an email and one's a letter on your letterhead.
You want to sit here, you can. We'll be close.
Okay, there's the email that Ms. Kaiser's email that was attached to
So
the
I'll put that as 3A.
requested determination. So those two, 3 and 3A, are actually part of the same thing. Let's see, that's, yeah, it's a 3-page letter from me.
That's the,
Exhibit
and then this one, 4, so you just need to.
Exhibit 4.
Yeah, you could just-
But you're basically finished, or, I mean, do we
Well,
have any further questions?
I was-
Go ahead.
So just to make sure that it's clear, so you, the response from Mr. Light was basically that Mr. Goff didn't have like legal authority to issue a cease and desist order because he's not the zoning administrator. So how did it come to you? When Mr. Light's letter came, which is exhibit 3 or 2, one of those over there, how did it get on? Did you hear about it directly from Mr. Light, or did you hear about it from Mr. Goff?
Both.
Okay.
At the same time?
So Mr. Goff sent you Mr. Light's, because Mr. Light, I assume, didn't know that you were the zoning administrator then.
Correct.
So you got it from Mr. Goff?
Yes.
Okay, and he said, okay, you're the zoning administrator, you answered.
And then the Dodds requested the determination.
Okay, from you,
Yes.
okay, good. And that's how your letter came to me,
Yes, sir.
okay. And I think her letter speaks for itself.
So that would be exhibit 5.
Did
Do you have?
her letters, yeah,
Yeah.
the next one from Michelle's letter should be whatever we're up to 5. Good. That's a mess.
Is that it?
No. Did Mr. Goff provide you with any legal authorities, or did he give you any guidance on writing your letter?
Yes.
And what legal authority did he give?
We reviewed the letter, we reviewed the code in response to each question that was raised.
So it would be correct to say that your response of November, 17th, I think, was written based on your collaboration and sort of consultation with Mr. Goff?
That's correct.
And he reviewed it before you signed it and
Yes.
sent it?
Yep.
All right, did he discuss any case law with you? No, just what's in the zoning ordinance? Okay. He didn't discuss any state code provisions?
We touched on a few state codes,
I mean, about tourist homes or about the procedure of what you're?
tourist homes.
Okay. I don't think I have any other questions.
Okay, Jennifer, do you have anything? No? Okay. I guess at this time we'll hear from the,
Guess I would also,
not plaintiff.
since we're,
Appellant.
since we're doing exhibits,
Do you have another one?
well, if we're going to put in the determination, you probably need to state, I don't know how your process works on this, every BZA is a little different. Things that have been submitted to the record generally are just part of the record, you don't have to go through it, but the statement of justification from the Dodds,
This one?
It's a-
With the email attached? Yeah.
I don't have the email attachment, I've got the statement.
Yeah, there is a.
That's the,
That's the date on that.
That's the 29th of January.
Okay,
this
that's
is
what,
2016, that's the attachment.
Yeah.
Oh, no, that's enough.
so that's what
That
they
goes
sent
with- that
after,
goes with it.
in support of their
That
appeal?
goes with it. Yes.
There should be called appeal justification statement, you know.
This one?
And there should be a copy of another copy of the email from Ms. Kaiser.
And I'll put
attached.
that as 6A.
Okay.
It's gonna be in
Okay, so,
Well, Mr. Chairman, I'm going to raise a point of order, I suppose, or a point of evidence, and that is, I don't see how a statement from somebody who isn't here and it isn't sworn can be admitted in evidence.
What
before-
statement was
For
it?
the Dodds, whatever is in there,
Oh, their letter?
their letter, they're not here.
I don't think the rules of evidence, Virginia rules of evidence apply to the BZA meeting.
Did anybody ask you?
Hold on, no, hey, listen.
you're not the attorney
You're
here.
not our.
You're not our attorney.
Well, so, okay, I mean, we have all this other evidence that was submitted with that.
No, Michelle is here, and she testified, and she verified all those exhibits and all those
This
letters.
was exhibit 6A.
And I'm just raising the question, are you gonna let it in or not?
Yes.
Because it's hearsay.
Their writing is not hearsay.
It certainly is, it's a statement that they're not making here under oath. Everybody else is gonna be sworn and give sworn testimony, and that's just the letter
Okay,
there.
well, then you can go ahead and present. Let's let him present.
Thank you, Mr. Chairman. You prefer me to stand or sit, or
Sit.
that
I
correct?
think you're fine.
Okay.
Are you gonna swear him?
No, I'm not
we
making an
have to
argument.
swear
I'm not giving
attorneys.
testimony.
I
I'm
don't
a
know
lawyer.
if we swear attorneys. We haven't before.
Okay, I'm just asking.
Okay, I'll make this brief. Mr. and Ms. Dodd are appealing the zoning administrator's determinations found in paragraphs 1 and 2 of her November 17th letter, which you've already discussed. To begin, the Dodds have been relying upon a written determination dated January 30th, 2016, in which Debbie Kaiser, who was then a zoning official with Rappahannock County, stated that the Dodds home could be rented as opposed to being classified as a tourist home as long as it was rented for 30 days or longer. A copy of that email has been provided in your materials. Consistent with that guidance, the Dodds have rented their property for minimum rental periods of 30 days. In fact, that's reflected in the VRBO.
Excuse me, I'm sorry to interrupt you, but Mr. Chairman, I'm gonna object to this. This is not argument, he's stating facts now, and he's not sworn. Do you know of your own personal knowledge who they've rented to and for what
Okay,
period?
hold on a second.
Right.
Well,
Hold on
why
a
can't I
second.
say my thing and get it, I want to get it on the record, because for all I know, this could be appealed, and I want to make clear, if the board's going to vote to allow this, good, then that's what you're voting to do, great, or maybe not so great. But Mr. Light, who just said, I'm not going to testify, I don't have to be sworn, is now, he just made a statement. The Dodds have been renting, whatever you just said, whatever's in that letter,
Okay,
it's a
now, hold
statement
on.
of fact.
Is it
You know
not-
what? It doesn't seem like we can continue this without our own attorney present.
Well, yeah, but there is an issue of the.
Is that not so? I mean, isn't that what you're saying, David? We're not attorneys and we don't understand what you're saying.
No, I
Okay,
think
well, let me
we're okay.
explain, if Alex will stop interrupting me, I'll explain to you real simple. We have to decide this based on the facts and the evidence and the law, what's in the zoning ordinance. So, part one, we got Michelle's testimony and her letters back and forth, and she testified, she's here, she was sworn. Now Mr. Light is giving the Dodds side of it, but the Dodds aren't here, only he's here, and he's stating facts, like he just stated. I mean, I'm okay if he wants to argue the effect of whatever Michelle put in, but when he starts to say, the Dodds did something in reliance on what they got from Debbie Kaiser, that's a statement of fact.
That's
And what,
Okay, now,
Wait a minute.
hold on.
and so he's not sworn, how does he know?
I understand.
Well, no,
But
no,
I
I know.
understand, but the thing of it is, you are an attorney.
Well,
And you're arguing. Nobody sitting on this board was picked because of our legal expertise in that
Okay.
sense.
No,
So if we're gonna be picked for this type of law, then we need our own attorney sitting here. I know you're a lawyer, but
Okay.
you're not the
I'm-
board's attorney. So if we're going into that mode,
Well, who's
we
that
need a
gonna
lawyer
be?
here.
Who's that gonna be? It can't be Art Goff because he's the county's attorney.
Well, then
Okay,
they have to
now-
hire one.
Is it not true that attorneys all the time make arguments in court?
Without being
And,
sworn.
and they're not sworn, and they
Not
say,
supposed to
my
say.
client maintains X and my client
But they
maintains
make
Y."
that argument at the end of the case after their client got up and raised their right hand and took an oath to tell the truth and then testified and put in documents that are now in
Okay.
evidence. So they're arguing about the evidence. Mr. Light is trying to wear two hats.
Okay,
He's
let's
trying-
do
It would
this.
seem to be germane in this situation if there were any evidence to the contrary of what the Dodds have asserted. At that point, there would need to be some ascertaining as to what reality is. In this case, we don't have any evidence
Wait a minute, wait a
to
minute.
the
No,
contrary.
hold on, let me answer your question. I think the issue is, it doesn't matter what they've done. We're simply answering whether this ruling is correct. So I think in deference to David, if we can just keep it to the point of talking about her ruling and the justification of your position.
Well, and that goes, and again, the 2311C is one of the issues, okay?
Right, I
Well, he can't, that's right, and he can't make that point without saying, proving a fact. And to answer Mr. Bird's question, if you read what's in the zoning ordinance and what's in the state code on appeal, the ruling and determination of the zoning administrator is presumed to be correct. And the burden of proof that it's incorrect is just the opposite of what you said. They have the burden of proving that what the zoning administrator determined is not
But
correct.
she did not
You're
determine.
changing things here. We're not arguing that. We are arguing as to whether or not what they assert as to the use of their property is the truth.
No.
And
Well, how do they assert it though?
No,
they
wait.
say they have abided by the
No,
ruling.
listen, it doesn't
about-
matter what the
They
truth
say what?
is.
They're not here.
No, it doesn't matter. Is her determination that it has to be rented out for 30-plus days, is that correct?
And part of it, realize.
Can he address that?
He
Chairman.
certainly can, but he can't go into this other
Okay,
thing.
okay, we got it.
All right.
Mr. Chairman, one of the things here, as you see from the letter, from the determination letter, the 2311 issue was not addressed by the zoning administrator. So therefore, the presumption of correctness would have no applicability because, to the 2311 issue, because it wasn't addressed. What we're saying is that my clients received an email, written determination from Debbie Kaiser, which was in the materials, from January 30th, 2016. And that email, and in fact, looking at Exhibit 4, which was put in, it says in the VRBO, it notes that the minimum stay is 30 nights. So therefore, my clients have, consistent with that guidance, they have rented their property for minimum rental periods of, consistent with.
That's what
Debbie's-
you say.
No, wait.
Have you
Okay,
been there,
okay,
sir?
Hold on. Just,
Okay.
it doesn't matter what that is.
Pursuant
No,
to,
it doesn't.
so therefore,
We're not determining whether they violated that letter, we're only determining whether this is an appropriate determination.
So pursuant to 15.2-2311C, the guidance that the Dodds received from Ms. Kaiser cannot be modified or changed by Ms. Summers. 2311C states that after a 60-day period in which the person agreed, here the Dodds, have changed their position in good faith reliance on a written decision requirement, decision or determination by the zoning administrator or other administrative officer, then such written determination is no longer subject to change, modification, or reversal. Now, responding to one issue Mr. Connick said earlier before we started this about whether you are bound by a previous determination, there was a 2017 Virginia Supreme Court case on point. That is Board of Supervisors of Richmond City versus Rhodes, 294 Virginia 43, 2017.
You got a copy of it?
I have a marked up copy of it.
City of Richmond versus Rhodes?
Board of Supervisors of Richmond City versus Rhodes.
And you're gonna sign.
RHO?
RHOADS, 294 Virginia 43. And
Can you tell us what that?
yeah, that's, in that case, the issue was similar to Mr. Connick's argument, the city asserted that they were not bound by in this case, it was a certificate. Let's see.
Yeah, you better read it.
It was a if I remember correctly, it was a certificate that basically was a zoning clearance. And the argument of the board, or the Board of Supervisors, was that the zoning administrators was dead wrong on the law, and it was void ab initio, which used to be the law under Seegeloff. However, the Supreme Court said that in the Rhodes case was that 2311C, which was adopted after Seegeloff, created a remedial statute. And it said that and basically what they held was, even if the previous determination was wrong and was objectively wrong, it still didn't matter, because once the remedial statute, in this case 2311C, the 60 days had passed, they'd gotten a written determination, and they had changed their position, then not only was the zoning administrator bound by it, but also the Board of Supervisors bound by it, because the zoning administrator is the agent of the Board of Supervisors. So, and again, that came out last year. So regardless of whether this board views Ms. Kaiser's determination as correct, whether they view Ms. Summers' position as correct, she cannot in any event apply her determination to the Dodds property under 15.2.2311C.
If they changed their position in reliance on the determination and took some action like spending money or some other thing, isn't that what the case says?
The case says you change your position in Rhodes.
Okay.
It said
right.
that, but you change your position by giving, again, minimum 30-day rentals.
But that is not what the court talked about in Rhodes, I'm sorry.
Okay, now this is interesting though, because you're arguing one side.
I'm just pointing out that what he said is a completely incorrect statement, although it's not completely incorrect, it's only half of what they said.
But you're arguing one side of the case,
I'm not arguing
which
one
is, it
side of
seems
the
like
case.
we're supposed to be hearing an objective
I
body.
just want to make sure that if
Okay.
he wants to put his case in, let him put his case in, and we can all read it. And you can read it too, and then I'll cite to what I'm talking
Okay,
about.
well,
Okay.
go ahead.
Because
All right.
that's,
Here,
because
I'll-
what he
I'll-
said is not accurate as to what the
Let's let
statute
him
says.
speak, let's
All
let
right,
him
it's
speak.
fine.
Okay. Now, if you decide the 2311C issue, then that's dispositive of the issue before you. However, assuming for argument's sake that you don't agree with the 2311C issue, the problem is that by mandating that rental property leases be for terms of at least 1 year for purposes of quote-unquote settling down, using the language of the zoning administrator, we believe that she has improperly imported requirements and concepts absent from the code's plain language into that code via administrative interpretation. Second, the interpretation is inconsistent with prior county practice as well as persuasive statutory authority. And finally, the interpretation would import an unworkable framework for distinguishing a tourist home from a by right rental property.
From a, excuse me, what?
From a by right rental
Oh,
property.
by right, sorry.
Let me briefly discuss these. To begin, an administrative determination cannot be supported by importing concepts and language with no basis in the language of the county code. Under case authority, a zoning ordinance should not be extended by interpretation beyond its intended purpose. Moreover, in the absence of contrary statute, because zoning ordinances are in derogation of the common law, they are to be strictly construed in favor of the landowner. We agree with the zoning administrator's recitation of the definition of a tourist home per 170-8 of your county code, which states that the term for accommodation for paying guests is generally longer than 7 days. We likewise agree with the zoning administrator that the code does not set a time frame for rental. Nevertheless, the zoning administrator bases her opinion that a 30-day rental will be considered a tourist home on the observation of, quote, a single-family dwelling is a place for a family to settle down, unquote. Neither the concept nor the phrase settling down is found anywhere in the plain language of the county code. Moreover, the county code recognizes that a single-family dwelling unit may be occupied by either a family, which is a defined term, and 2 roomers or boarders, or 2, a group of 4 people not necessarily related by blood or marriage. And for that, you can find in the county code section 170-29 as well as 170-80.
What are those definitions?
The definition, a single,
What, the definition of what are you?
if you look at single-family dwelling unit or single-family dwelling, that's in 170-8, which makes explicit reference to 170-29.
I read it today.
Hence, the code contemplates that a single-family dwelling may include different combinations of family and renters without reference whether, for example, roomers or boarders plan to settle down in the county. Simply put, the plain language of the code focuses on an occupant's identity, not their intent. She also asserts, despite her acknowledgement that the county code does not set a time frame for rental, distinguishing between the rental home versus a tourist home, that rental homes are rented for a year's term and paid on a month-to-month basis. Her determination is that to qualify as a rental, the lease must at least be for a 1-year period, which is a concept not found anywhere in the plain language of the county code. Thus, she has imported a 1-year leasing requirement into the code where no such requirement exists. Indeed, it's worth observing Virginia law recognizes unwritten month-to-month residential leases. The zoning administrator's interpretation would seem to render unwritten month-to-month leases illegal as well. The zoning administrator is legally prohibited from basing her determination on language and concepts which she has read into the code. If there's a problem with the code language, it would need to be instead addressed by the Board of Supervisors as part of a legislative action. Next, it is the Dodds understanding, both from their interactions with Ms. Kaiser and others, that it has been common practice in Rappahannock County for some time that rentals for 30 days or longer did not require special use permit for a tourist home. This practice was apparently based in part on the fact that per Section 151.71, now 151-72, the county code, facilities offering guest rooms for rental periods fewer than 30 days were subject to a transient occupancy tax. As an aside, the Commonwealth of Virginia has recently passed a statute permitting localities to require registration of properties used for quote-unquote short-term rentals. This can be found in Virginia Code Section 15.2-983. The statute defines short-term rental as the provision of room or space that is suitable or intended for occupancy for dwelling, sleeping, or lodging purposes for a period of fewer than 30 consecutive days in exchange for a charge for the occupancy. And again, that's
What did you just read from?
Virginia Code Section 15.2-983, subparagraph A. Thus, this new statute supports the county's consistent past practice. Finally, the zoning administrator's interpretation, we believe, would create a chaotic and unworkable framework for county property owners who are renting residential space. The November 2017 determination, which would be presumably applicable to everyone in Rappahannock County, would mandate leases with 1-year terms. Virginia law allows for month-to-month residential leases to be unwritten. Indeed, such unwritten month-to-month leases are fairly common. The zoning administrator's 1-year lease term requirement would thus be impossible to determine. Presumably in that case, the zoning administrator would then need to determine whether the tenant intends to quote-unquote settle down in Rappahannock County, an inquiry which many would find invasive. More importantly, the concept of settling down absent code guidance would lend itself to highly subjective case-specific determinations. Such determinations would provide no guidance to county property owners who wish to maintain compliance with the zoning ordinance. Now, there has been, my understanding, there's been an issue raised about a 1940 case, v. Ledbetter, which is 175 Virginia 170. I had a chance to, I'm familiar with that case, and I had a chance to reread it, and I think it's distinguishable. One is the Ledbetter decision deals with only the question of restrictive covenants and their interpretation. By contrast, there are no restrictive covenants at issue here. Indeed, localities have no jurisdiction to enforce restrictive covenants. Second, the court in Ledbetter was interpreting the meaning of the phrase residential purposes as used in those specific covenants at issue at that time. Here, the code does not use such language, but instead uses the term single-family dwelling. And in fact, as we discussed, the definition of single-family dwelling contemplate the presence of roomers or boarders, which was not the case in the covenant language at issue in Letback. So in conclusion, and for these reasons, we believe the board should overrule the zoning administrator's determination and rule that rentals of 30 days or greater are not tourist homes. Or more specifically, the board should rule that due to Ms. Kaiser's 2016 written guidance, the zoning administrator's determination does not apply to the Dodds property per section 15.2.2311C. Thank you.
Thank you.
Okay, so then we have a rebuttal period. Do you have any response to what he said? No? I guess there'd be no rebuttal to her response. There's no response.
What?
She did not make a response.
Yes.
Okay.
Yeah.
Okay.
What about it? You gonna let anybody else talk?
Now you had two people who wanted to say something?
I mean,
No,
yeah.
that's fine. Ma'am, did you want to speak? No. Sir, did you want to say anything?
I think you have to open the public hearing and then close it.
I just opened it. Nobody wants to speak. Oh, Beverly, go ahead.
I don't want to speak to this case specifically, but I have been in and spoken with Ms. Summers, and I have a really bad feeling about some of the things that have been cited there, as far as length of time, as far
In
as
this
what,
letter.
yes, as far as what's considered a family unit, who for the county is going to oversee that, who's going to say, are they a family unit, do they plan on to settle down? I'm speaking from the standpoint that as a realtor and representing landlords, I don't know where I would go with this. I mean, I can tell you, I have a lot of people that come in that don't stay a year. The Inns tenants are a prime example. Most of those kids show up here, they go to work there, they want it on their resume, they're here for 6 months, and they're out of here. They are not planning on settling down. So I don't think I could administer it. I don't know how I would tell my landlord, are you in conformance or not in conformance? Those are the things that I just think that if this were ruled upon as it stands, there's a whole gamut here that's going to be opened up, and I don't know who would be able to enforce it. I don't think Ms. Summers could. I know the Commissioner of Revenue's office couldn't. I mean, they can do the 30 days, but who's going to gather the information? Were you there 60 days or were you there 180 days?
And so you were the Commissioner of Revenue for a long time?
Correct.
Okay.
And we do, what happened is normal. We do check the VRBO site, we do the Airbnbs. If someone's advertising short term, then they get a letter. So that's very normal. I just don't, I don't know any way to enforce over 30 days as being a tourist home, because there's nothing that would give us a tool to do that.
Okay. Thank you. Is it anyone else?
I guess I should have.
Could you introduce yourself?
Yeah, I'm James Watson. My wife owns the before and after over on Main Street in Sperryville. We've been living out here since about April of 2015. Last year, this last Christmas, we were out in Texas. Our pipes burst, and we don't have anywhere else to go. Things like the Dodds property is what pretty much saved us, gave us a place to stay without having to leave Rappahannock or have to go somewhere quite expensive until we figured out what's next. I don't want to state facts and things like that and be objectified, but I got to say that, to your point, we're not here as tourists. We're here to, stay. But where we stay for a temporary period doesn't mean where we're going to stay long term. We're staying in Sperryville long term. This house is a temporary place for us until we find that place. Yeah, that's all I have to say.
Okay, thank you. Anyone else?
Me.
Okay, introduce
I'm
yourself.
Kevin Day. Yeah, Ms. Summers' interpretation of anything less than a year's lease could qualify as a tourist home puts a lot of people in violation in this county. I was a landlord myself for many years, and I always had a 30-day, month-to-month rental lease with my tenants. And it worked to the benefit of both of us, you know, they didn't, if they wanted to get out, 30-day notice. If I wanted them out, a 30-day notice. And that would be different if they were on a year's lease. I would have to wait till the 30 days before the anniversary date unless they violated the terms of the lease. And when my wife and I were first married, we rented month to month. We were young and we didn't know if we were going to be planting roots here or somewhere else. And it really worked to our benefit as well as the landlord. But we lived there for over 2 years, month to month. And we didn't even have a signed lease, not even a signed one. So if this interpretation stands, there's a lot of people in this county that are in violation of the tourist home.
Okay,
Thank you.
thank you. Someone else?
I think my only comment, my name is Cecile Gardner, and I live not very far from the Dodds, and was part of the group that was opposing them when they were doing daily rentals. They were not doing 30 days, they were basically doing 2-3 days at a time. My big concern is that I don't have a problem with the 30-day, but the concern we had was that it was like they were switching it over like every 2 or 3 days. And we know that because everybody in our little hollow would go up and down. We take pictures of the cars because we know they're only there for 2 or 3 days at a time. So they weren't honoring the 30-day notice. This is the first time we've had somebody there for as long as he's been here. And, you know, we had restrictions and they've completely gone, you know, those have gone by the wayside. We asked that there not be a fire pit. They still have a fire pit out there. So, I mean, I think that the 30-day thing and the year thing is a separate issue to our issue, which was the fact that they were renting for less than 30 days.
Okay, and that's not really the issue
Right.
that's before us, you understand?
You know, I'm sorry, just one more thing.
Okay.
If you rent for 30 days and you don't stay there for 30 days,
Yeah,
that probably benefits the landlord of getting all the 30 days money and not the wear and tear.
Right.
2 days? Yeah.
Okay, is there anybody else? Okay, I'm gonna close the public hearing, thank you. Do we have any further questions or comments? Do I hear?
Are we gonna discuss it?
Yeah, let's, did you want to say something?
No, I don't know, I'm gonna hear what the rest of you also have to say.
I'm happy to start if that would work.
Go ahead.
Okay, you know, I, in looking at Michelle's letter, since we're talking about that, now she's not really saying that it has to be a year at a time. She is saying most rental homes that are single are leased for a year. It's not requiring a year, but she is saying, you know, most. So I think in some cases, these definitions are a statement of sort of condition, or like in the ordinance, we say tourist homes are generally more than 7 days. I don't know any that are more than 7 days. They're all less than 7 days, as far as I can see. So some of, you know, like 2 days, a weekend, maybe a week. So that is typically a tourist home. So our definitions are not necessarily correct. They do not necessarily reflect what the practice is. Now, Michelle was attempting, I think, to, I mean, I can see where you were going with that. And I think you were attempting to make a difference between a resident and a transient. Or, I don't even know if you call them a transient, because a transient's a resident. But someone who's like a visitor who comes and goes. I mean, I get that. I think to the point that has been brought up that I see is if this is generally going to be the interpretation of the law or of the code, then it does put, I think it is true that there are a lot of places that you'd have to really look at to be fair. You wouldn't just focus on the poor Dodds. And I know that there are really high profile, very controversial, because of the situation and, you know, the publicity and all this. I get that. But I think you still have to say, well, then we'd be looking at everybody in the county. And I know of multiple instances of people who come for the summer to stay. They come for a month or two. Somebody might house sit. And there are even cases of contractors who rent a house for 3 months while a job is going on. They're not going to be residents. I don't know who's gonna be out there figuring all this stuff out, and I think the enforcement is virtually impossible. And so I think this is practically not, I think it's a nice ideal. I don't think it's practical that our county could enforce this. And I don't think it would be fair to only enforce it against the Dodds or any one particular individual because they happen to be, have broad attention to themselves. I think you'd have to somehow make sure that it's on everybody, and I don't think that's gonna happen. And so I would be inclined to say that if there is a problem with the tourist home definition, which I think there is, I think that the Planning Commission and the Board of Supervisors should be addressing this, and I think they're addressing other issues. I think our ordinance is not particularly up to date in some ways, and I think it could be improved upon, so I think that's a great thing. Now, the other thing that I would comment on is back to, and I don't know the code section really, but the principle that I look at is, can we rely upon these determinations by a zoning administrator? And I think, and I really feel like had it not been this transition period going on where Dameron passed it off to Michelle, who Dameron got it from something that happened with the previous zoning administrator who was previous to a previous zoning administrator. And so John was here, John McCarthy was here when this initial letter was done. Debbie followed him, then David Dameron, then Michelle. And all of this in the course of not even 2 years, right? And so I feel like if they would have known that there was this previous determination at the time, none of this would have come up. That's my feeling. And I feel like that there's a lack of consistency in saying, okay, what determinations have been made about this property? And I know of another instance where a determination was made and they get a cease and desist later, a year after it's all been resolved, because there's no record kept of these previous letters. And that is true, correct? I mean, they're not, you can't look back and see what's been done. So I do think that going forward, I think we should have some way of tracking these things so that you could look up a parcel number and say, okay, on November 7th of such and such a date, this opinion was made. Go back and look at it before we send the cease and desist letter. I'm not criticizing you on that because you didn't know it was there. Probably had no way of looking it up. But I think if we did know that these things were out there, there'd be no cause for this determination to be made. I think it was already made. And so my point of view is that would be that issue would be that I don't think there was a call for this. And so regardless of the merits of this letter, I don't think that we should put this forward as something that's binding on everybody. That's my opinion. I pretty much agree with that, and I believe that the letter from Kaiser should have, with the codes that you were stating, 2307 or 2311C, probably should be the one that stands, the 30 days.
Yes. The ownership of land is thought of as a bundle of rights and privileges to that land. In this case, one of the privilege involved has to do with the ability to rent it. This is a common and generally done operation. And the difficulty that we are dealing with now is that in our zoning ordinance, there really isn't any good definition of what a short-term or a long-term rental is. And as far as I'm concerned, whether that makes any particular difference to the operation of renting the property. And the fact that there was a previous determination by the zoning administrator that 30 days was the difference between a short-term and a long-term rental was the common practice in this county, albeit it was only engraved in or described in the ordinance by the fact that if it were for less than 30 days, the rental, it would be subject to a lodging tax, which longer-term rentals are not subject to. And in this situation, to be told summarily that the previous practice and the previous zoning determinations are invalid and no longer standing seems to be a somewhat arbitrary and capricious determination, which involves a lot of problems for a lot of people far beyond this particular situation. But we're not involved in that. We're basically involved with determining whether the Dodds have a right to rent their property for 30 days or more, which had been the common situation of long-term rentals in this county. And that it would seem to me that if we were to deny that, it would have to be as a result of a redetermination of what short and long-term rentals were, and it should be specified directly and unambiguously in the zoning ordinance.
And that would need to be done by the Board of Supervisors.
That would need to be done by the
Planning
board.
Commission recommendation,
Yes.
recommendation to the Board of Supervisors. Right.
Anything else, Bill?
I'm pretty much in agreement with that, but I don't see how, I don't know legally, not being an attorney, but it doesn't seem morally correct to give somebody permission to do something and then they do it and spend their funds to do it. And this was, now you can't do it, besides you can't do that. Other than that, being a builder and having rental property myself, we rent to people, we have people that are moving into the area that have had to sell their home in order to buy a new home, and they have to rent for 2 months, 3 months, whatever. And we have places that we rent to them that aren't considered a boarding house, so like I said, legally, I leave that up to Mr. Connick and this gentleman. But to me, morally, I think that people should be allowed to have continue it on 30-day basis.
Okay, thanks.
I think that, I know this is a very troubling case, because I think, to me, the main issue is the way that it's being advertised. And I think that a lot of what some of the people that in the audience said makes a lot of sense, and what you colleagues have said makes a lot of sense about what are going to be the ramifications of whatever's decided, especially if this is upheld. But I don't think that is something we're supposed to take into consideration in making the determination that we have to make, which is very limited. It's whether or not the zoning administrator's determination, which under the law is presumed to be correct, was not correct. There's nothing in the ordinance that really gives too much guidance about what is, when you cross the line from a short-term rental or a permanent type of residential situation to a tourist home. And I'm honestly not sure that just putting a number of days on it is the answer. It may be part of the answer. I mean, I think it's obvious that if someone comes and rents a place for the weekend and they never come back, or maybe they come back next year, that's obviously a tourist home commercial situation. If they come and they stay, 3 weeks or 28 days, then the ordinance really doesn't say, and doesn't give any guidance. And I agree with what Mr. Light said, which is that that zoning ordinances are, and what Mr. Burt said too, that zoning ordinances are enacted in derogation of people's private property rights, so they should be strictly construed when they're being used to limit what people can do. So when you get up to 29 days or 30 days and now 31 days, I don't think there's any magic in whether it's 29 days or 33 days. Obviously, if you get out to 330 days, then it's starting to look like they're really living there. And like this gentleman whose name I forgot, who's living there now, obviously he's not living there forever, but he's living there. It's not a commercial tourist home. And the point of this case that's been circulated, which was sitting here somewhere.
Is this the one right here?
Right. Right. The Dietrich versus Ledbetter case from 1940. What Mr. Light said is correct, that wasn't a zoning case, that was a case to determine the applicability or enforceability of restrictive covenants that you couldn't do commercial activities in that neighborhood, only residential uses. And that, I think, is relevant because if you look at our zoning ordinance, and these are I guess what I think are the two sections that are determinative. One is the section with the chart, which is 136. These uses are in subsection E, I think. Mm-hmm. And E is entitled Commercial, Retail, and Business Uses. And then, I'm not exactly sure, because I'm really not used to using this book instead of the computer, but there's a section in our zoning ordinance that says, or maybe it's 135, that if it's not in this chart, you can't do it. The only uses that are allowed are the uses that are listed here. So when they're what strikes me is that they're advertising for transient people on the VRBO website. That's in evidence. And that to me is searching not for short-term people to live there on a short-term basis. That's looking for people that are going to come there. And if you read, where is the ad? Because I handed my copy down the road. Where did it go? What's on the website? When I read this, Rustic Comfort in the Woods, it's entitled. And I just want to read what it says. Some of it. This house is very unique and with new renovations is ready to host your special visits to the country. We have tried to include many amenities for your comfort and ours, although the cabin is best appreciated as a retreat from city life. And as beautiful as this space is, please note that an old cabin in the woods may not be for everyone, and so forth. I think when you read it and you read the comments of the people who stayed there, it's pretty clear to me that they're not soliciting people. I mean, it's not like the rental ad that you see in the Rappahannock News or the Culpeper Star or the Washington Post, like 3-bedroom, 2-bath, house close to schools and shopping, X number of dollars a month. It's not even advertised at a rate
Now,
per
aren't
month.
you straying a little bit?
No,
from-
I'm commenting on what is a tourist home, what's a commercial use, and what's not. It's advertised at a nightly rent of $84 a night. It doesn't have a monthly rent, and in contrast to what Kevin and Beverly said, sure, there's a lot of short-term rentals on a month-to-month basis, but one of the ways you determine that as a matter of law is what's the rental period? And if the rental period is 30 days, then it's a tenancy of, from month to month, or if you pay the rent every week, it could be a tenancy from week to week. This is a tenancy from night to night, when the rent is stated $84 a night or a
It
day.
says average rent.
Okay, it says average rent, but it doesn't say what the rent is for 30 days. It's somewhere in there, yeah. That's one thing. The second thing is, Ms. Gardner testified that they have taken pictures and
That's
seen
what
people
she
that
just
come
She
and,
just stated.
all right,
But I thought that
whatever.
wasn't allowed because she wasn't.
Well, whatever, you let it in. I'm
Okay.
just saying, she commented that people have come and have not stayed there for 30 days. So it's a very difficult thing because on the one hand, I agree with what Mr. Byrd said, that the ordinance ought to be specific, and I agree with Mr. Light as well, that the ordinance ought to be specific and say what it means to say and where the line is. And on the other hand, I think this is a situation where someone may be trying to, or not, without really regard to the Dodds, if we don't uphold this decision, the other side, you've all said, well, it's going to be a lot of trouble if we do uphold it, but if we don't uphold it, it's going to perhaps open the door for a lot of people to circumvent the ordinance by just saying, hey, we have to rent this for a minimum of 30 days. And after the weekend's over, they default on the lease, go back to DC, and they say, whoops, they left. So now we're renting it again to
Now, how
another new
about
people.
in
because
answer-
those
That's
people-
speculation.
Well,
Spec-
so is what you all said, speculation.
Can't control every situation.
But I think Dave,
All right, wait a minute.
Dave,
I didn't interrupt you guys, I'm not finished. So I have trouble with it, and I think that, that personally, I would like to, as Mr. Anderson suggested, I think we ought to get an opinion of council. And I would like some time to review the authorities that have been submitted. I do want to say one other thing about this vested use business based on a prior determination. First of all, because of what I just said, and I'm really not being critical of Ms. Kaiser, she just basically reported what the practice had been by John McCarthy. And I think at the time that she said that, I'm not even sure she was already the zoning administrator or not. But I don't think there was any detailed particular analysis of the ordinance. It just said, this is what we've always done, so that's the way it is. Whether what we've always
I
done.
don't think she said that's what.
No,
we were
she listed out what she.
All right, let's see.
doing.
One second. Is this part of some other exhibit?
No, that's her letter.
Yeah, but wasn't this attached to something?
Yeah, it was attached to
It's
their,
attached to one.
to their letter, to their justification.
Well, it's about the tax and stuff, so it's not about the zoning ordinance at all. And I don't know, I mean, she cited a tax provision in support of a determination. There's not any reference anywhere in the letter to the zoning ordinance. Section 151 is the local tax on, what do you call it, the meals and lodging tax of our county code. It's not the zoning ordinance, and quite frankly, the zoning administrator doesn't have the authority to interpret tax provisions of the code. That's either for Commonwealth Attorney or the treasurer, I'd say. But what I am saying is, I don't think there's anything really in the ordinance that provides us with guidance. I entirely agree with everybody who said the ordinance needs to be worked on and needs to be amended to clarify this. About the vested rights, I want to say one thing about that. I don't think that this, as we all know, because this came before the board previously, this tourist home was built a couple of years ago and renovated, and they applied, and then they withdrew their application, and then they reapplied and withdrew that application last year.
Well,
So,
that was because of.
well, what it was because of is irrelevant. The point is, they've, by their applications on both those times, that constitutes to me a statement or an admission. They're using it for the commercial purpose that's listed in section 136E. Otherwise, they wouldn't have applied for any kind of a special use permit on either time. So I don't know where the line is, and like I say, I don't know what's the best way to resolve this. But I have a lot of troubles with it on both sides for all the reasons I've said. But the way I read the code, the interpretation of the zoning administrator is presumed to be correct unless they overcome a burden that it's not correct. And I don't see where they've met that burden. And I don't see where they've done anything based on the 30-day rule to, like, in other words, if they somehow added a room on, and that's what that case that was talked about, it speaks to. If somebody says, yeah, the zoning administrator comes out and says, yeah, you can build a chicken house right there, and you measure it and it's 40 feet, and the zoning administrator made a mistake and it's supposed to be 50 feet, but you've already built it in compliance with what they told you, right, that's a vested right. But just when you go in and say, can I do X, Y, or Z, and they say yes, no, or something else, and you don't do anything, you don't spend any money, that doesn't give you a vested right, in my opinion. So on balance, all I have to say is I don't think that they've met the burden. I'm not saying that I would have given that interpretation, and I would urge you all to rethink what you said. And we have some time to do this, so I think we ought to continue it, and I think we ought to hear from either Mr. Goff or some independent counsel what we ought to do.
Why didn't he come tonight?
Well, he's not our counsel anyway.
He was their
representing.
counsel.
I don't know why he didn't come. I don't, believe it or not, Art doesn't ask me what to do.
Okay.
Do it. So all things of what I said, I have a lot of, like I say, reservations. I'm not sure that I would have written the exact same letter or come to the exact same conclusion, but we sit here and we have to assume, and that's what's in the code, that her determination is right unless they prove that it's not right. And I don't think they've done that, so I would vote to affirm.
Well, why isn't Debbie's right then?
Well, we're not dealing with her determination
hold
because
on.
nobody appealed that.
No, he's making a judgment about whether he's made the case. I think he has made the case. You think he
Because of
hasn't?
this, of 152311C?
Yeah.
C.
I mean, I feel like he's made the case.
Well, then you
feel
can
like
vote
he doesn't,
accordingly.
so I'll vote accordingly.
Well, okay.
But is that enough discussion? Is there a motion?
Yes, I move that we,
Well, can I say one more thing before if you're going to vote, and that is this. I think we can affirm it, or reverse it, or modify it. And so if you people are concerned about 30 days, why don't you think about modifying that part of it only, affirming it in part, and then modifying the decision?
Well, a reason I wouldn't do that is I think that's a process that the planning commission and the board of supervisors can, hopefully they'll take that on. And-
Hopefully. When?
Well, I mean, no,
They've been
well,
sitting with a
No, no.
bunch of stuff
It's okay.
about
Let's-
tourist homes for 2 years now.
Well,
They
let's
haven't done it.
assume we'll add this to the mix, because I think it's a very valid point that's been brought up.
Okay.
And I don't think it's really up to us to set.
Well, I agree with
zoning
that. I
policy.
agree with that.
So, I'd be inclined rather.
Well, before you made your motion, I want you to know that you can either reverse it, or affirm it, or you can vote to modify it, so.
Okay, so are you voting to reverse it?
I am voting to
Moving.
reverse it.
Moving to reverse it.
All right.
Is there a second?
Say it, to reverse it.
To reverse it,
Not to
that's
affirm it.
correct.
To reverse the zoning administrator's
Reverse the
determination
zoning administrators,
and uphold the applicant's position.
that's correct.
Is there a second?
I'll second it.
there any further discussion? All in favor?
Aye.
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 No,
Okay, so it's 4 ayes.
Members of the BZA, thank you.
Now, I don't know where am I? You have it in the agenda.
It's,
We're conducting a meeting here. Everybody.
nobody's sitting here.
Okay. We're reviewing the minutes here.
I have page 2, and I don't have page 1 that we want to follow aside. This one.
Does everybody have a copy of this?
Those are the ones that are marked as exhibits. I am, no, that goes in your record. Okay. Because these are the exhibits.
I mean, I did not.
Yes, you're in charge of that, I was just a marker.
Where do you think is it? No.
Because these will be attached to the minutes from this meeting and we'll go and follow those.
Is there any comments about the minutes? Do we have a motion to adopt?
really, well done.
Yeah, you did.
Waiting for you guys to say. I mean, I
No,
waited
I
for
mean,
some-
I was fine, yeah, I like this. I like this better. Is there a motion to accept the minutes? Do you need to look at them? Bill? No, I'm looking at it. Is there a motion to approve the minutes?
I move so moved.
I'll second that they're adopted
As submitted.
as circulated.
Okay.
Okay, all in favor?
Aye.
Aye.
Okay.
Hooray. All right, I'll get you a clean cut.
Okay, so now, this is sort of an interesting thing that came up, and this is the appointment of the BZA representative to the Planning Commission. And we took the step of nominating David Connick. Chris Bird has had a term, and the supervisors determined at their meeting that it actually should be a 4-year term. So that nomination was not approved, and that's the status of that. So I don't know if there's anything to be done. We think that, we have thought that it's been a 1-year appointment each year, and it has been for 50 years, but it turns out that that wasn't the exact. And so, actually, there are people who are making sure that we're following the rules exactly as they are published. And so this had an unintended consequence, but anyway, that's sort of that. I don't know that we need to do anything. I think the supervisors are gonna be considering that. Is that, Don, is that correct?
One of the supervisors is bringing it forward for consideration.
For consideration, yeah. So that's something that may or may not be,
In the meantime, following code.
yeah, so in the meantime, Chris is staying on. I think the determination is that this would be his 4th year, I think.
That's
I mean,
I can't.
okay, he's had 3 years, this will be his 4th. No,
I think it's the third. But
I think you've
I've
been on it for 3.
I've been on it for as long as you have been chairman,
Right.
because I took your
And
place.
it was right after you came on.
In 2015, so he's for 15, 16.
So this is his 4th year. Yeah,
Never get Connick to do math in public.
yeah, so for what it's worth,
Right.
so either it's gonna come up next year for a 4-year term, depending on what happens, or I think it would be nice if we just went to annual appointments, just because that seems to make sense, but anyway, we're not gonna lose a lot of sleep over it, right?
No, we're not. And I would like to just thank Alex for, and all the rest of you for your, I guess, vote of confidence. And, that's the way the cookie crumbles, I suppose. I really wasn't aware of that provision in the code, believe it or not.
Daggone law.
Yeah. So, no, but I mean, that's what it says, so that's what it says.
Hold on, Gary,
Just as it may be,
you can tell everybody who you are, just.
maybe of interest to people here, Gary Curry,
Who's that?
County Administrator for the last 2 months. The agenda for the March 5 meeting was published today. This topic is an item on the agenda for consideration by the board as to whether they want to move forward with a subsequent public hearing to modify 170-139C, which is a section of your zoning ordinance that speaks to seating members for the planning commission. So if it's of interest to you, then you may want to come to the board meeting, speak in public comment. It's not a public hearing. There would be a public hearing subsequent to that if the board decided to move forward and change the ordinance.
Thank you.
Thank you. Is there any other comments? Okay. The next thing, and this seemed to be a question that came up, is there any clarification of the responsibilities of the BZA clerk?
Well, I just wanted the board to, or at least talk to the board and with the zoning administrator here, because until now, the zoning administrator and the clerk, the secretary of the board have always been one and the same person. Now that it's not, I would like to, and I think that's going to help us with our procedure of making sure applications are complete, that when things come in, you're going to let me know, and I'm going to be the one that reviews it, sends it to the planning commission. That'll be the green light for an ad for them. And personally, I think unless it's something really complicated, some of these standard tourist homes, now people are having to wait 2 months. In other words, we're not having the BZA hearing the week after the planning commission. We're not doing it until the next month, or to some other future month when we know the planning commission has acted on it. And so I think we ought to try to go back to doing it more quickly. But anyway, Michelle, the way I see it, and that's what's in our rules of procedure, that when the applications come in, when you think it's complete, you call me or write me, and then I'm going to come in and I guess I'm going to have a cover letter to the planning commission. It says, dear planning commission, we're going to consider this on such and such a date. You need to put it on your agenda, review it, and get us your recommendation by that date, and then go ahead and do the advertising.
Well, they got into a backlog or a log jam, and so they were at the planning commission, and so they were delaying things. They were tabling them.
Right.
And so then they would want to come back and get more information, not particularly about the application, but about the concepts that were going on. So if that's cleared up, and then we could hear it the next week, we could do that. But until they get some of that log jam,
Well, is that an official policy now?
I think the board of supervisors actually did adopt something like that.
Is that?
I'm not sure that it's their
In other
bailiwick
words,
to do that.
waiting until the planning commission has actually made a recommendation prior to advertising for the next meeting of the board of supervisors or the
BZA.
BZA. Is that a policy or is that just a
I'm not
practice?
sure that, I believe that was.
Because it was
We
discussed.
talked about a timeline for.
with the special exceptions and the special use permits and
That's
so
all
forth,
tabled.
people were showing up and they weren't.
One of the troubles is the advertising, because if you do it the way that they, a two-step thing. In other words, the way we used to do it, we had one ad that cost, give or take, $275 or $300. And in that ad it said, either the Board of Supervisors or the BZA has before it this application. It's going to go to the Planning Commission on such and such a date, and then the public hearing at the permitting body is going to be on another date. And that was all in one ad, which you can do because the law says the ad has for the public hearing has to be at least 7, but not more than 21 days ahead of the meeting. So if you have a month apart, you have to do 2 ads.
Two ads twice.
Right, you have to do 4 ads. You have to do 2 ads for the Planning Commission and 2 separate ads for the BZA, whereas we were doing 2 altogether. So it increases the cost to the county by, by about $500 or $600, more like $600 or $650, and the permit fees that are supposed to cover that cost don't cover it. So that's kind of the issue. If that's really what everybody wants to do, the supervisor ought to change the fee schedule So I'm sure Mr. Curry is writing that down. I mean, you gotta do one or the other. Either we go back to doing it all in 1 month, or we ought to increase the fee schedule. The fee schedule is pretty high as it is right now. It's $500 or $600 for a special use permit, so I don't know that that covers it. I don't know where that number came from. I don't know when the last time it was amended. Not that I recollect, so.
But
But
the
anyway,
other
that's
thing is for service to the client, if you want to call them that, people who are making application, why do they have to wait an entire extra month? Especially, that's the thing, when they could have it all resolved fairly quickly. And I've always told people Rappahannock County is very efficient. It's not like Fauquier or these other counties where it takes 6 months or 8 months or something. You can get something done, or you could, and maybe still do, in a month, basically. You could get a planning commission and go ahead.
But I see the zoning administrator's
Oh, go ahead.
smiling here, because I think part of the discussion was it was too compressed. In other words, there wasn't enough time for matters to be considered. By the time it made it out of the planning commission, it either went to the BZA or the board of supervisors, or the planning commission felt that it needed more time to study it, and it felt pressure to turn it around right there the first time they heard it, without, and other counties have work sessions, or they have a more deliberative process. So somewhere in between what you said and what I think is been one of our strengths, and hey, you don't have to wait around forever. You can get this thing in and out of here, and you can get it done in 30 days. That's also served as part of our weakness, because some things are just getting pushed through too quickly without perhaps enough deliberation. Not to say it would take 6 months or 9 months like other counties.
No, but one thing.
I don't know if you want Michelle to pipe in there, but I
Well,
think
there
that
is
was.
one aspect, just before you pipe in. On the advertising, it's my understanding that if you can open the hearing at the Board of Zoning Appeals, and you could say, okay, we want to table this because the Planning Commission wants to hear it again, and that does not start a new advertising requirement.
Right.
So it could actually come to us, and we could say, oh, the Planning Commission didn't make a recommendation
Then we can
because
hear the people that.
they need, and then people could say something, and then it would go back to
Recess.
the planning commission. We don't need to advertise it again. And I think the big thing was not, I'm sure about this, it was not necessarily getting more information, it was because we were having mess ups in the advertising.
And I think part of that
And I
was.
think that was the thing, it was, we were missing the dates, we were having to
That's what I was gonna
postpone.
point out.
And I don't think we need to miss these dates, really. And I
Plus,
think
I'll be doing the ads now, then
Well-
be right.
They'll happen directly.
if it's one ad, for, one ad covering both meetings, I don't think we need to have a mistake. Like,
No, well, I'm gonna be putting the ads in.
yeah, but I think Michelle's perfectly capable as well, for the supervisors or whoever's doing
Well, for the
that.
supervisor, that's right, she'll
I
be
mean,
doing theirs.
I just think that
With
it's,
Gary.
you get it in on a certain day, if it works, fine, if you miss the day, I guess it goes to the next month. And I don't see that we need to change the whole system because we made a bunch of mistakes on advertising. And that's really what it boiled down to.
Well, I think
There was
there's
a couple of things that there's,
And I think the planning commission, if sometimes they say, well, we want more information, that information that could simply be provided to us, the applicant could get it together during that week. It doesn't necessarily have to go back to them to review. You could say, well, hey, you need a letter from the highway department for, an entrance permit or whatever it is. And they could just get that and bring it to us. And the planning commission says, okay, you should have this, and bring it to our meeting.
Well, we've already fixed that by the application and the checklist, so that stuff's gotta be in there before it gets advertised.
But
So
they could
I don't
ask
think-
for something else.
Okay.
I don't know what that is, but, water
So
study.
we'll use our judgment. So what's the consensus? We should go back to trying to do it all in 1 month? At least
Well, I
advertise
don't know,
it?
is that our call or not? I don't know.
Sure it is. It's our, the applications are made to
Go
us.
ahead, look, Gary.
I just have a couple questions. Relative to the agenda item and the role of the secretary in this process, trying to reconcile that with 17055 applications, which directs the zoning administrator to take certain actions. So I'm trying to figure out how does the secretary fit into applications when they first come in that would be heard by the planning commission.
It's in the rules of procedure of the BZA. The applications come to the zoning administrator, and he or she takes that application on behalf of the board, either this board or the board of supervisors, depending on if it's SP or SE. Then, by rights, somehow it has to get in my opinion, either the clerk of the board of supervisors, if it's an SE, or the secretary of the BZA gets it from the zoning administrator and refers it to the planning commission and says, planning commission, the board of supervisors is going to take this up, or the board of zoning appeals is going to take this up on whatever such and such a date and have its public hearing. You've got to have, you've got to have your recommendation in by then, and then that's the way it's always worked. But you've always, up until now, well, or almost up until 8 months ago, the clerk of the board of supervisors, the secretary of the BZA, and the zoning administrator was all one person.
So
And now I think it's 11 people, right?
17055C says the zoning administrator shall refer the application to the planning commission, ... So that's the zoning administrator.
Okay, she can refer, but anyways, but.
So I think we need to, parse through that very carefully and make sure.
Well, that probably ought to
we're
be.
following the code, and the rules of procedure for the BZA are important, but certainly they are.
Okay, well, let's not.
They don't.
Well,
They don't
it-
overrule.
further
the code.
down, it says the zoning administrator shall take action necessary to see that the advertising requirements are met. And I think that's what you're referring to, is that it comes in and then the advertising, which is secretary, which is the splitting
Sure,
between this.
and I welcome the assistance of the secretary to ensure that the advertisement is correct, particularly because the BZA wants to make sure when you hear a public hearing, when you have a public hearing, that it's properly advertised. So that's, I think, excellent. I just want to make sure we're doing what this says first and foremost. And if there's anything in state law that trumps this, that we're doing that. In the proper hierarchy. With
So what he's
BZA rules and
suggesting
procedures,
is,
just under.
let's not change our procedure tonight. But I think we would
Sort through
like to change our procedure, so if you want to figure out how we can do that, that would be great.
I just say, let's read this,
Okay.
and then go from there.
So you're saying the zoning administrator ought to do it all?
I'm saying whatever these words say is what should happen.
Well, what you just read,
Is that the county ordinance?
Yes.
Yeah,
Okay.
right here.
Okay, and if it could be modified and improved, we could
There's a
do-
process to it.
Okay. Okay, is that cover our conversation?
I
I
can't.
think we've got, is there anything else? Is there a motion to adjourn? Is
So moved.
there a second?
Second.
All in favor?
Aye.